Hello again. My name is Douglas Pinkham with Pinkham and Associates. We are a dedicated family law firm here in Southern California, and we practice exclusively in the areas of divorce and other family law issues. This particular video is dedicated to the FL 130, which is the appearance, stip, and waivers. You are going to need this form when you complete your divorce. If you guys have an agreed upon judgment, you're going to agree upon the issues at the end of your divorce, you're going to need this form. It's a very simple form, so I'm just going to go through this one pretty quickly. It's only got a few boxes, and you want to mark, well, I'm sorry, let me start at the top. Again, just like every form, your name and address and phone number go on the top. Your name when you're dealing with attorney 4. You put your name in there if you're handling your own paperwork. County of, you want to put the county where you're filling out your form, the address where that court is at, and the name of the courthouse there. Then the petitioner and the respondent, you want to list those names. The petitioner and the respondent, as I always say, are always the same. It's the same petitioner that filled out the petition at the beginning, and the respondent is still the other party of the case, the person that filled out and filed the response. Then you're going to want to list the case number off to the right. And we are off and running on the meat of this form. Okay. You're only going to want to mark the boxes that apply. Under 1, it asks about the appearance of the respondent. If the party already filed a response, and filed the response, then B applies because they have already previously made a general appearance. A general appearance just means they filed their paperwork with the court. A would be marked if they are making a general appearance by filing this form alone. They've never filed a response before. They're only going to file this form. Then you'd mark A. 90% of the time, they've already filed a response, so I'm going to mark B. Okay, C, you would mark if you are a member of the military services for the United States, and you have completed and attached this form, declaration and conditional waiver of rights under the Service Members Civil Rights Act of 2003. It's an FL 130A. So if you are a member of the United States military services, go find the FL 130A, and you're going to want to fill that out and attach it to this form. Okay. Number 2 is agreements, stipulations, and waivers. So only mark the boxes that apply, and I will tell you the boxes that apply in 90% of the cases, probably way more than 90% of the cases. Number 2A. If you are agreeing on this case and the judgment and you want a judge to sign your judgment, you're going to mark A. It simply says that the parties agree that this cause may be decided as an uncontested matter. That means we don't want to go to trial. We don't want to fight about it. Okay, 2B, you are going to mark this box if you're filling this form out for any reason. You're definitely going to mark B. What it says is we don't want to go to trial. So we're waiving rights to notice of trial, a statement of decision, a motion for a new trial, and the right to appeal. If you're not going to trial, you don't need any of those. You're not going to need them, so mark B. 2C says this matter may be decided by a commissioner sitting as a temporary judge. I always tell my clients, we'll mark C because we don't care who stamps this paperwork. Once you guys agree on your judgment and you want it to be finalized, who cares who fills it? Who cares who signs it? A judge, a commissioner, magistrate, anybody that has the authority to do it, who cares? Number 2, sub D, the parties, you're going to mark this if you guys have a written stipulated judgment. Some people call it a marital settlement agreement. Don't call it that. Call it a stipulated judgment. It's a technical reason. Just do as I say. Okay, so the parties have a written agreement that will be submitted to the court or a stipulation for judgment will be submitted to the court and attached to the judgment. So if you have a written agreement that says this is what you're going to do and these are all the things you're going to use, that you want the court to order, and you're both signing the bottom of it, you're going to mark D. If you're using a bunch of forms, then you're not going to mark this box. If you're just using a bunch of forms that apply to child visitation, custody, child support, spousal support, property division, then you're not going to need to mark that box. Okay, so if it's just forms. Now E, I don't very often recommend marking this box. Now, let me explain it real quickly. This box says none of these agreements or waivers will apply unless the court approves the stipulation for judgment or incorporates the written settlement agreement into the judgment. Now, when you have made the decision to end your marriage and end your divorce, and you have come to agreements on all the issues, and you've put the paperwork together, and you've both signed everything, and you've submitted it to the court for final judgment, do you want any delays? Do you want the court to say no to certain issues, or do you want your judgment to be delayed until everything is finalized in maybe some other forms? My answer is probably not. You probably want this judgment to be a real order, a real finalization of your issues when you sign it and submit it to the court. If that's the case, then don't mark E, and the date you sign your judgment is likely to be the date that is held as the final judgment date. Well, let me take that back. The date that you made the agreement. The final judgment date is positively going to be the date that the clerk or the judge stamps your judgment. But think of it like a contract. If you don't mark E, it's kind of like signing a contract. These orders are real now when we sign them now. If you mark E, they don't become a real agreement or a real order until the judge, or not a real agreement, and say the contract, for example, wouldn't go into effect until the judge stamped it and signed it on the judgment date. So I typically do not mark that box. It's up to you. And then this is F this is a parentage case. Both parties have signed advisement of waivers of rights. We're talking about a divorce, so this is not our case. Again, under other, I mentioned this on another video. I've never used that box. I don't know what would go in there. I don't have anything that I've ever put in there. You can leave that blank. Then, of course, you're going to date the form, write your names where they go. This is the petitioner on the top, respondent down here. Put the dates on your left above your name, and then sign to the right. And that is the appearance, stip, and waivers. If you have any other questions, feel free to give us a call. Again, my name is Douglas Pinkham with Pinkham & Associates. And again, we are located in Southern California, but we can assist you in information you need or even help you fill out forms no matter where you're located in the state of California. Thank you and have a great day.